the purpose of this press conference is to announce both our reasoning and the details behind the legal case that we'll be bringing against the General Assembly's actions of last night. And if I were to boil it down, I would say a couple of different things. I would say, one, this is not about the vetoes, and it's not about the stimulus. If you look at the last 6.5 years that I've been here, there have been a long number of vetoes that have been overridden. That is not new. But what is new is the action that the General Assembly took last night with regard to a couple sections of the budget. And as a consequence, what this case is ultimately about is one, balance of power in this state. You know, I'm going to be gone in 1.5 years, and yet if we allow this decision that they have made to hold, it's going to set precedent for the next governor and the governor after that and the governor after that, and as a consequence, the, quote, balance of power that exists or does not exist in this state. It is secondly, I think, ultimately about far-reaching consequences if yesterday's action holds with regard to upsetting the apple cart on what amounts to 200 years of legislative process in this country. And I'd say thirdly, to me, is about this larger question of why have a governor if the hands are constantly tied of the governor, he or she, who might hold this office down the road. Now let me elaborate on each one of those themes. One, this is about balance of power. And at some point there is always a straw that breaks the camel's back. And let me just, I jotted a couple of these thoughts down on the back of a card, and they're simply representative of the unusual structure that we deal with in South Carolina. You know, we're the only state in the union with a budget and control board that handles the administrative functions that are handled by the other 49 governors in the United States of America. We're the only state that actually has the public utility regulatory agency elected by the legislative body. We're the only state that actually has a workforce agency elected by the legislative body. We're one of only 3 states where the majority of the members of the state university boards are elected by the legislative body. We're one of only 2 states wherein judges are elected by the legislative body. We're one of only 2 states where the Supreme Court is elected by the legislative body. We're the only state where project timelines are subject to legislative control and projects are not part of a long-term capital budget plan, as is represented through the Joint Bond Review Commission. We're the only state, if you look at the opposite side of the equation from the standpoint of executive branch limitations, that, you know, popularly elects its adjutant general. You know, the conversations we had with regard to check on power with regard to the lieutenant governor's office in this state relative to the governor's office. A long list of very unusual components, but this really is, again, one step further on, again, this breach to the balance of power that ought to exist for a functioning and efficient government in South Carolina. And I say that in this light. The governorship in South Carolina administers a whole host of different federal programs. And, you know, they range from Medicaid monies to Workforce Investment Act monies to Community Development Block Grants to Appalachian Regional Commission to Justice Assistance Grants to Law Enforcement Grants to Burn Grants to DOT, go down the list. And nobody thinks twice about this, again, executive function of administering federal law. I mean, nobody from the legislative branch comes in and says, tell you what, we're going to reconfigure the way that you administer Appalachian Regional Commission monies. It is not done. And so here we are with a new federal law. In this case, it's called stimulus, but you could call it Appalachian Regional Commission Part 7. And you have federal code that says this is what you're going to do, and these are the rules. And in this case, for the first time, you have the legislative body coming and saying, don't care what the federal code says, this is what you're going to do. And that really is an unprecedented breach with regard to the balance of power in this state. Because the code is very, very clear in giving the governorship the power to apply or not to apply for that 10% of the stimulus monies that's been in question all along. And so the question you've got to ask yourself is, if we allow the legislative branch to come in and usurp power that has been granted through a federal law, where are we in terms of balance of power in this state? And I guess in a larger form, what this represents is an unprecedented power grab vis-a-vis legislative body to executive branch. So I think it's one about balance of power. And as a consequence, I'd make point two, it has very far-reaching consequences. Because what you're really talking about is arbitrarily allowing a state legislative body to change federal law. And I think that that has a real consequence for 49 other governors in the United States of America, if for either political reasons, blue state, red state, all the different scenarios that you can draw, wherein you could have a legislative body that could come in and arbitrarily change the law that a governor would be administering, maybe of a different party, maybe for political reasons, but there are a lot of bad scenarios that could be drawn in that instance. I would say, secondly, it draws very strange, or would create very strange consequences with regard to federal lawmaking itself. I myself was a member of the United States Congress. I spent 6 years of my life in the United States Congress, and there were a whole host of laws. I remember when we passed welfare reform, there were a lot of state legislative bodies that didn't think welfare reform was such a good idea. Do you now want to have individual legislative bodies, in essence, be given the power to undo a federal law? I mean, I think that's a pretty big question, because it really goes back to this heart of turning on its head 200 years of legislative tradition in the way that things are done. I guess I'd boil it down this way. I would say that we may do things very strangely in South Carolina, but there is no reason, based on this decision that was made last night, for us to export the manifestations of a strange legislative structure that comes as a result of a totally faulted 1895 Constitution that was put in place for racist reasons by Pitchfork Ben Tillman. And so it is really that larger issue of, do we export the manifestations of a strange governmental structure to other legislative bodies and to national circles if we allow this to stand? And finally, I would say there is this larger question, why have a governor? I mean, within the federal code itself, there are 4 requirements, basically, in terms of assurances or accountability by which you draw down these funds. And what the provision last night said was, no, none of that matters. You just accept the money, period. And so it's for those different reasons that we're taking this course that we are. I've talked to a whole host of people who I admire and or whose opinions I value. In terms of our own legal counsel, in terms of Lindsey Graham, I talked to him. He's the United States Senator. I mean, in fairness to Jim DeMint or Lindsey Graham, again, think about the erosion that could take place in terms of our own congressional delegation in passing a law that ultimately, in essence, is vetoed by a local legislative body. And so I would invite you to talk to Lindsey Graham, just because he has a law background, former prosecutor. And we talked at length about the, again, implications going forward if this thing stands.